Morning, right? I will be taking you through public law as a trial class today, right? And I've chosen the topic of the rule of law to discuss with you. Rule of law is one of the more fundamental concepts in public law. You could say that when we talk about constitutional law in any country, the very fact that we commit ourselves to having a constitution and the very fact that we talk about having some kind of limitations on the power of the those who govern, we have already committed ourselves to the concept of the rule of law, right? And I always like to tell this little story about what Saint Augustine had written a long time ago in the 5th century AD, right? Saint Augustine had spoken, right, about the incident involving Alexander the Great, right, and the pirate. So there was apparently an occasion when Alexander the Great had arrested a pirate. That was causing a lot of trouble, right? And Alexander the Great had asked the pirate, right, "How dare you molest the seas?" And the reply from the pirate was, "How dare you molest the whole world? Because I do it with a small boat, I am called a pirate and a thief. You, with a great navy, molest the world and are called an emperor," right? And that really is, in some sense, a key issue, right? What St. Augustine was trying to show was that there's no difference between a pirate and an emperor, right? Alexander the Great is reputed to be a great empire builder, no doubt, right? But the problem with all of these emperors, kings, right, was that they were really the biggest bullies in town. They were basically just the people who went around killing, looting, plundering, right, and building their empires, right? So when we look at it dispassionately, we realize that most great emperors were not subject to any legal restriction whatsoever, right? They were all powerful. And if they chose to abuse power, there's nothing much that we could do about it. So very early on in St. Augustine's City of God, he talks about the fact that a government or a state without any restriction, without any sense of justice, is nothing more than a band of robbers, right? What are states without justice but robber bands enlarged? Just a band of thieves, right? No difference between a government and a bunch of individuals who are robbing if in the end the state is not based on concepts of justice, if the state is not based on concepts of law, if there's no legal restriction on the king or no legal restriction on those who govern, right, then the very basis of governing itself is questionable. The legitimacy of governance is questionable, which is where the concept of the rule of law comes in. The idea that government must act in accordance with law. What I have here is a quotation from Joseph Raz. When you eventually enroll on the program and you study this course, when I conduct the rule of law topic, one of the jurists, right, one of the philosophers that we look at is Joseph Raz. And Joseph Raz talks about how the idea of the rule of law is different from the concept of rule by law, right? And he says this: in its broader sense, this means that people should obey the law and be ruled by it. So this is one sense in which we understand the rule of law, right? When we talk about rule of law, we tend to think of law and order. We tend to think about the fact that citizens must follow the law. We must adhere to the existing laws so that there is some level of stability and security in a country. That is one sense in which we talk about the rule of law, stability in a country. But there's another sense in which we talk about the rule of law. In a narrower sense, in legal theory, rule of law is more about the fact that government must be subject to law, right? So he says, in legal theory, it is read in a narrower sense, i.e., that the government should be ruled by the law and subject to it. This is often expressed as government by law and not by man, because this distinction differentiates the concept of the rule of law against that by rule by law. So for instance, we could go to North Korea and we could say that, fine, in North Korea, they have a constitution, they have a set of laws, But having said that, just because you're governed by using law, you can't really say that that is the rule of law, right? So the rule of law is a slightly different concept from just saying that a government acts in accordance with law, right? There are certain restrictions on what government can and cannot do. Potentials for abuse of power, even using law, is actually questionable, right? So we distinguish between the concept of rule of law as a higher concept, as opposed to rule by law, where those who will seek to abuse power may actually just use the law to justify their power, right? Now, this picture that you see here is a depiction of a scene along the Thames River. The Runnymede is the place that we're looking at. And what you see here is in the background, you can see some tentage and all of that, right? There was a battle that had been fought, right, back in 1215 AD between King John, the man that you see there sitting down signing that document. That's King John. And John was a king who had a bit of trouble with his lords and barons. He was known to be quite wasteful, and he engaged in a lot of wars. And at one point in time, that meant that he had to raise exorbitant amounts of tax. So, of course, he will turn to the lords and told them to impose higher and higher tax on the peasants. The lords, at some point in time, realized this is not tenable, right? We need to control this king, right, and what he's doing. So there was a battle that was fought between the lords and the king, and eventually there was a settlement arrived at, and that is the document that the king is signing, the Magna Carta, a very famous document signed in 1215 AD. The Magna Carta, to some extent, represents in English law the first time that a king's power was restricted by law. Whereas in the past, we could say that the king is the law, now we would say the law is the king, right? So it is no longer possible for the king to act in accordance with whatever he wanted, according to his own whims and fancies. The king was now restricted by this document that he had just signed called the Magna Carta. The Magna Carta is also, of course, referred to as the Great Charter of Liberties. It's very well celebrated in many parts of the world, right? A copy of this document actually came down to Singapore in 2015, marking the 800th anniversary of the Magna Carta, and it was in our Supreme Court. They actually displayed it for 1 week here, right? So some of our students actually went over and took a look at the document as well, right? So it is no longer really a live document as such, but having said that, it represented that promise made by King John that he would not arrest anyone and put that person behind bars unless the person has first been presented before a court of law. All right. So I have this quotation here from the Magna Carta. What you see in the background of this slide is actually a copy of the Magna Carta, right? No free man shall be seized, imprisoned, stripped of his rights or possessions, outlawed or exiled. Nor will we proceed with force against him except by the lawful judgment of his equals or by the law of the land. To no one will we sell, to no one deny or delay right or justice. Okay. Now, in modern terms, this proposition in the Magna Carta is referred to in a truncated form as there shall be no punishment unless there is a breach of law, right? A promise by the king that he's not going to send you and put you behind bars, right? That he will first charge you with an offense in a court of law. You'll be found guilty through a lawful judgment of the court. And then after that, you'll be imprisoned, right? So that's a very key concept in the idea of the rule of law. And we still have that concept very much enshrined in the way in which we expect the British government to behave, so that nobody is in fact arrested and convicted without trial. You need to go through the process of a trial and be convicted before you can be thrown behind bars, right? So that brings me to the concept of the rule of law that many believe that the United Kingdom adheres to. And of course, this is part of what we do in our subject as well. We look at the theory of the rule of law. Professor Dicey, that you see over here, right? In the late 19th century, he wrote about the concept of the rule of law as practiced in the United Kingdom. UK may or may not adhere to the rule of law properly, but part of what we do as an academic exercise is actually to understand the concept of the rule of law and then go on to analyze what has in fact happened in terms of case law, in terms of political events in the UK, to see whether or not the UK government really adheres to the idea of the rule of law. I am not going to go into all of the postulates of Professor Dicey, nor am I going to go into the academic controversies and the critiques. That's part of what we do when we study. But at this point in time, it will be sufficient for me to just let you know the first postulate of Dicey. And he says this: we mean, in the first place, that no man is punishable or can be lawfully made to suffer in body or goods, except for a distinct breach of law established in the ordinary legal manner before the ordinary courts of the land. In this sense, the rule of law is contrasted with every system of government based on the exercise by persons in authority of wide, arbitrary, or discretionary powers of constraint. Quite a fair bit in there. And that's also something that we kind of go into a bit of detailed analysis in class. But for now, from this, we extrapolate and we say that there shall be no punishment unless there is breach of law. You and I cannot be deprived of our liberty. You and I cannot be deprived of our goods. You and I cannot be deprived of our life unless we have breached a law. So of course, if let's say there's an offense stating that you cannot commit theft and you have committed theft, and the prescribed punishment for that is, let's say, imprisonment for 6 years, then of course the state is entitled to charge you for the offense, bring you to a court of law, find you guilty, and then after that imprison you, right? But what they can't do is that they can't imprison you without any basis whatsoever, right? And that's the whole promise that we have under the rule of law, okay? Now, although I am not going to go into all the three postulates of Dicey today, right? But very briefly, when we talk about the three postulates of Dicey, they are basically what you see here on this slide. No punishment unless there's a breach of law, equality before the law, and judges are the best protectors of liberty. What I'm going to do in the next few slides is actually just to look at the concept under the first postulate, no punishment unless there's a breach of law. What do we mean by that? The fact that you are not deprived of your life, your liberty, and your property unless there's a distinct breach of law, and the fact that there will not be any use of wide, arbitrary, or discretionary powers by the state. That's the promise that is made under the concept of the rule of law. The rule of law is not law. The rule of law is just purely a political doctrine. We use that political doctrine to judge politicians. We use that political doctrine to judge the way in which government performs its functions, right? So the first example I'd like to look at, right, in terms of the way in which the rule of law operates, is this rather old case, Antic against Carrington from 1765, right? The picture that you see there is an image of the sheriff having entered into the premises, ransacking the papers, right? Antic was someone who was actually a writer, and what the minister had done was that he had ordered or issued a warrant to his sheriff to enter the premises and look for any potential items that might be seditious, right? They wanted to charge Antic for sedition, right? So they were fishing for information. They couldn't find anything appropriate. So they went into the house, they unlocked the place. They took about 4 hours ransacking the entire place, right? And they took whatever they could from there. But of course, in the end, there's nothing seditious that was found, and he was not charged for anything, right? Now, of course, Antic was not too happy, and he sued Carrington. Carrington is one of the king's messengers who was actually in the premises. He sued him for trespass, right? So Carrington and his colleagues were sued for trespass by Antic, and the question that arose in court was whether or not trespass was made out, right? And of course, what the defendant's argument was, I was there with a lawful warrant. The minister had issued a warrant for me to enter the premises, so I was entitled to search the premises and take whatever property was there. Right? Now, the court questioned that premise. The court said this is unlawful. A minister has no power to issue warrants. Right? And the issuing of a warrant is not done by a minister. In those days, right, when we talk about entering somebody's premises, the police would have had to get a magistrate's warrant before they enter the premises. Right? And the minister himself had no such power. Right? So the fact that the individual purported to enter the house with the minister's warrant would mean that he had done so unlawfully. He had infringed upon somebody's property rights unlawfully. Right? So Lord Camden, who was the judge in the King's Bench at that point in time, presiding over this case, right, stated this in his judgment. The great end for which men entered into society was to secure their property. That right is preserved, sacred, and incommunicable in all instances, where it has not been taken away or abridged by some public law for the good of the whole. So a concept that is quite latent in English law is the idea that our personal property is sacrosanct. Whatever we do within our personal property is our own business, that nobody can come into our premises without our permission. That is still true today, even in Singapore, right? Nobody can enter your flat or your house without your permission, right? And even the police, for that matter, right? If they're just going around asking questions, they will stand at your door. They're not going to enter your house. If at all they're going to enter your house, they need to have lawful authority to enter your house. To do so, they need a proper warrant for the purpose of entering your house, right? And this is what Lord Camden went on to say. By the laws of England, every invasion of private property, be it ever so minute, is a trespass. No man can set his foot upon my ground without my license, but he is liable to an action, though the damage be nothing, which is proved by every declaration in trespass, where the defendant is called upon to answer for bruising the grass and even treading upon the soil. If he admits the fact, he is bound to show by way of justification that some positive law has empowered or excused him, right? So the point is, if you enter into the premises, so in this instance, in this case of Antic and Carrington, right, when Carrington entered the premises, there's no justification for him to enter the private property of an individual. And he claims that the minister gave him the warrant. The court was of the view there's no law that allows the minister to do that. So clearly, there is an infringement of the personal rights of the individual. Antic and Carrington is one of many cases that we will look at, many interesting cases involving government attempting to abuse power and the court stepping in to say that, no, that's not the law. You cannot lawfully exercise those powers. And it's a reflection of this whole rule of law concept that we are talking about. And in terms of this rule of law itself, right, when we spoke about the idea of imprisonment, I mentioned the Magna Carta. I said that under the Magna Carta, King John had promised that nobody will be imprisoned unless in the first place he is presented to a court of law. That promise has held true throughout the centuries. There's this concept of due process that we have in criminal proceedings, right? That every person, when you're charged with an offense, you're presented in a court of law, evidence is presented against you in a trial, you have an opportunity to rebut that evidence, and at the end of that, the court will decide whether or not you are guilty. There's no such thing as minister decides you are guilty and you'll be thrown behind bars. That would go against the very idea of the right to liberty that is part and parcel of the first postulate of Professor Dicey, which is that no person shall be imprisoned unless they are subject to the law, right? So if, of course, you happen to commit an offense under the law, then you can be charged for that offense and found guilty. But under no circumstances can you actually be detained without trial, right? That's a basic concept that we have in the right to liberty. Now, however, it was quite shocking in the year 2001 when the UK Parliament passed the Anti-Terrorism Crime and Security Act. Of course, in the lecture, I'll be looking at quite a lot of other instances of potential abuse, but I'm highlighting this particular incident because in the year 2001, the 9/11 attacks took place, right? And when the 9/11 attacks took place, in the UK itself, the UK Parliament passed this particular law, Anti-Terrorism, Crime and Security Act, introducing indefinite detention without trial. It was particularly shocking, at least in the academic world and those who are concerned about human rights, it was very shocking that the UK would pass such a law within their own territories, right? And so then subsequently what happened was the law was challenged in a court of law. In the case of A and others against the Secretary of State for Home Department that you see over there were individuals who were detained without trial under that particular law. The picture that you see there is a picture of Belmarsh Prison, right? Belmarsh Prison is where some of these guys were actually detained without trial. The minister alleged that they were terror suspects and they were detained indefinitely. That was challenged in a court of law. The case went all the way up to the highest court in the land, and the court decided that the Anti-Terrorism, Crime and Security Act was not compatible with Article 5 of the European Convention of Human Rights. Now, those things are matters that we learn as part of the syllabus. We'll learn about the European Convention of Human Rights, the different articles, and there are occasions when there's infringement of those articles by the government, and the UK courts are called upon to make a determination on that. And in this case, what the court did was they declared the law to be incompatible. But unfortunately, the United Kingdom does not have a written constitution. The courts do not have power to declare a law to be invalid. The most they could say is that the law is bad law, but it's still valid law. Right? So they say it's incompatible legislation. We were left with Parliament to decide what to do. To be fair to the UK Parliament, 2 months after the decision was made in the case of A and others, Parliament went ahead to change the law and they removed the provision on detention without trial. So for a brief period between 2001 and 2005, UK in fact flirted with the idea of indefinite detention without trial, when all the way from 1215 AD, the promise had been made that nobody will be imprisoned unless they were subject to the lawful judgment of their peers, right? But we're back to square one again. We're back to the position that, yes, nobody will be imprisoned unless they are, in the first place, subject to the lawful judgment of the courts, right? Now, kind of running a little bit out of time, so I will end my session on this rule of law topic at this point in time, right? And I will hand over to my colleague, who is Chang, right? You saw him earlier, David Chang, and he will take you through contract law. And after that, we'll do a short Q&A again.
The world is changing exponentially. Humanity will see more changes in the next 20 years than it has in the past 300. What we do will change. How we do it, even more so. Be ready. Join the education revolution designed to impact and transform lives. Access 300 world-class programs in over 40 areas of study from over 30 international partners and affiliates in an education ecosystem like no other. Become a future-proof global graduate now. Own your future.